Hello, all. Welcome back to another session of Legal Essentials for Human Resource Management. Now, this is week 8, and we are going through session 39 of our course. If you remember our discussions till now, we were looking at how to conduct domestic inquiries, and in our last session, we have looked at the procedure where you have to give a charge sheet or a showcase notice and then get a response from them. And if the response is not satisfactory, you select an inquiry officer or inquiry committee, and then they go on to for a fact finding kind of understanding if the misconduct has happened or not. And we have also discussed about the principle of natural justice, which says that the accused person should be given enough opportunities to put his side of the story forward. So, when I say enough opportunities, it means that he should be provided an opportunity to look into all the witnesses as well as proof that is produced against him, and he gets a chance to cross examine the witnesses if you find any any fact which they are saying is not correct. If you feel so, it's a chance for him to cross examine also, and then he gets access to all the proofs, all the supporting documents and reports, as well as the final report. So with all this information, I think it's a good time to get into the second phase of conducting domestic inquiries. So without much delay, let's start today's session, which is a continuation of how to conduct domestic inquiries. I hope you know my name by now. It's Dr. Amesh Amaloparan, and I'm from Nalsa University of Law. So continuing from last session, you should also understand this concept of nature of inquiry. So what is this concept of nature of inquiry? Uh, when it is a court procedure, the court goes in with the assumption that for a person to be deemed guilty, there should be enough evidences that makes the court believe beyond reasonable doubt that this person is guilty. So only when there is enough quantum of proof and witnesses that can let the judge conclude that beyond reasonable doubt this person is guilty, he can be called guilty. But the nature of inquiry in domestic proceedings is a little liberal in comparison to court's rules of procedures. An inquiry officer kind of performs a quasi-judicial role for sure, because he summons people for inquiry. He produces witnesses. He inquires witnesses as well as accused. So it's a quasi-judicial role, and hence he should consider all relevant facts during the inquiry. He should also not consider any fact that is irrelevant to the charges. Also, I told you, previous assumptions about him, previous history, and all can be used to build a context, but you should not base your assumptions on the base of irrelevant facts. And you cannot also shift the burden of proof or reject the relevant testimony of witness only on the basis of certain hearsays. So these are all similar to what happens in court. The burden of proof is with the person, not with the accused. But how it changes here is that inquiry officer cannot also inquire into allegations on which accused not has been charged with. Now let's look into inquiry proceedings and how time, date, and place of inquiry should be informed. So prior commencement of an inquiry, it is necessary to provide the accused employee with the details of the inquiry officer before whom he should appear. So he should be completely aware who is going to be the inquiry officer, and what time, date, and place he should be reaching. So that details has to be given beforehand to the accused employee. Also, while fixing the venue of the inquiry or hearing, uh, the venue should be fixed in such a way that it may not cause hardship to the accused employee. And if it is such that there is some distance or something, travel allowance can also be given to the concerned employees. So the inquiry officer, by all means, is giving the accused all the chances to come up to the inquiry and defend himself. Though we say that all the opportunities should be given to the accused employee, it doesn't mean that he has a right to pick the venue. That is definitely not there. But of course, there is this provision to provide travel allowances for all if required. Another question that has always been asked is that can a defendant bring in a lawyer so that they can defend him properly? So ideally, the employee has no right to representation in the inquiry proceeding by another person or a lawyer. The idea is that the employer has to defend himself in front of the inquiry committee or inquiry officer. But let's say the company have certain service rules or certain standing orders adopted by the company. In that case, it is possible. So the whole idea is that it's a discretion of the employer to provide this facility of being represented by a lawyer or a third person. Being said that, the general practice is for employees to argue their own case before the domestic inquiry. In Crescent Dyes and Chemicals Limited versus Ram Naresh Tripathi case, it was clearly established. So I'm just giving you certain case laws which support this stand that it's a discretion of employer, and employees doesn't have the right to bring in a lawyer or a third party to defend him. So in this particular case, it was established that an accused does not have the right to be represented by a counsel or an agent until the law specifically confers this right. There's also this Anna Sahib Dattatreya Sanbur versus Garvare Wardrobes Limited and others case, where employee challenged his termination due to misconduct, citing that his request for an advocate to represent him in front of inquiry committee was denied by the employer. So hence his argument is that his natural justice was denied, given that he couldn't bring a lawyer who could compellingly defend his position. But the High Court have rejected this argument. So there's clear legal case laws which says that in an inquiry proceeding, the employee doesn't have the right to represent him through a lawyer. Do the accused employee have the right for an inquiry report? Now, the common proceeding is that inquiry officer shares a copy of the report which is submitted to the employer. A copy is given to the accused employee also. But courts in India have over and over said that the right to receive the copy of the inquiry report is not absolute. And just because this inquiry report is not given to the accused employee does not mean that the entire inquiry proceeding and the punishment arising out of it is invalid. So it's not a absolute right, but it would be a good practice to share the inquiry report with the accused employee also. Now, what is the role of management in implementing these decisions? Make no mistake, let it be IC committee as per the POSH Act, or a disciplinary committee, or a inquiry committee, or an inquiry officer. None of them have the power to take any actions against the employee or worker. The right, or rather the power to take an action against the employee or the worker is reserved with the employer, and hence it's the management who have to implement this decision. So it is very important that the management should maintain some distance from the inquiry officer and the entire proceeding. Then there should never be any pressure that comes from the management to influence the inquiry officer that a particular decision should be taken, and any proof of such will compromise the integrity of the domestic inquiry that has happened. And once this report is ready by the inquiry officer, this report is submitted to the employer, and there would be recommendations given by the inquiry committee or inquiry officer based upon the existing service rules in terms of what appropriate action can be done against this employee. And it is not absolute that the employer has to follow these recommendations. If the employer decides not to take actions, it is fine. But often employers will take actions because then there is no much complications out there, and you take anything above and over what is recommended from the inquiry committee can also land in trouble. So the best way forward would be to adopt the recommendations provided by the inquiry committee or inquiry officer. Now, let me introduce you to certain fundamental concepts that you should be aware while conducting domestic inquiries. And one of them is standard of proof. So I discussed this a little before also. The standard of proof in domestic inquiries is lower than in a criminal trial. So it's not too much stringent as a court criminal trial, where the whole principle is based upon the idea that the guilt is proved beyond reasonable doubt. In domestic inquiry, the misconduct must be proven based on the principle of preponderance of probability. So this principle of preponderance of probability means the inquiry officer or the inquiry committee comes to a conclusion that there is a more chance that this misconduct has happened in comparison to a chance that this misconduct has not happened. So it's based on the determination that a reasonable person would have come to a conclusion. So that's the idea. Would have it more likely happened or not? Would have happened or not, based on, of course, the evidences and the witnesses that you have received, and you then conclude whether it would have happened or not. So it's not an absolute conclusion or an absolute proved beyond reasonable doubt. That much stricter standard of proof is not here, and you follow with the idea that okay, there's a higher chance that it would have happened considering the evidences. So a classic case is Employers Management West Bokaro Colliery of Tisco Limited versus concerned workman Ram Parvesh Singh. Now what happened is that there was an allegation against an employee for riotous and disorderly behavior towards his superiors. Now based on these testimonies and among other evidences, the employee was found guilty in the inquiry and was dismissed from the service. Now, the industrial tribunal had set aside the report by the inquiry officer, and the order of dismissal, order of the dismissal was set aside, believing that the management had not substantiated the charges beyond reasonable doubt. So this is a case which established the standard of proof concept for a different standard of proof for domestic inquiries. So the Supreme Court said that yardstick and standard of proof in criminal case is different from the one in disciplinary proceedings. So the standard of proof is as strict as in a criminal trial, and it follows a principle of preponderance of probabilities. There is a higher probability that this would have happened. The committee or the inquiry officer can come to a conclusion that this has happened. So that's why you'll often see a scenario where there was a criminal act. Let's say there was a physical assault that has happened or alleged to be happened, and the case was running parallel in the police station and went to the court, as well as a domestic inquiry was happening. The court said that there is not enough evidence to believe beyond reasonable doubt that such an attack has happened, and the case was dismissed. But the domestic inquiry have concluded that such an attack has happened and have given certain punishments to this employee. A classic case is of cricketer Srishant. The court had dismissed because there you need to be proved beyond reasonable doubt. But then a BCCI felt that it's a domestic inquiry, they just have to follow the principle of preponderance of probability and conclude that he have indeed committed a mistake. Though later it was again gone to the court and it was quashed. But any which ways. Another concept you should be aware of is ex parte inquiry. Now all this is concepts that we have discussed until now is on the assumption that you give a showcase notice to the accused, he will respond. Then you call him for disciplinary inquiry, he will come. You ask him to submit certain proof, evidences, as well as any witnesses that can support him, he will provide all those. You ask him to cross-examine the witnesses as well as evidences given by the other party, he will cross-examine. We are all going by this assumption, but sometimes it can happen that the person who's accused, he might decide not to respond at all. You give a showcase notice, I'm not responding. You call me for an inquiry proceeding, I'm not coming. What happens? Till now we said you have to follow natural justice, and if the procedure of natural justice is not, principle of natural justice is not followed, maybe whatever action you take may be quashed in the court. But the whole idea is that if you have actually given him the showcase notice and then he have not responded, you can still conduct this inquiry as ex parte inquiry. You have given him opportunity to come and give his a side of the story, but he have not turned up. Now we can't do anything about it. If they don't cooperate or they don't show up for the inquiry despite reasonable opportunities to be given, and that too without any cogent reasons. They say, I am admitted in my hospital in my ICU and I cannot come for it. Those are valid reasons. Imagine they are not giving any reason, not responding, not turning up for the inquiries. Then you have given them enough opportunities, and then the entire principle of natural justice is maintained here, and you can conduct an ex parte inquiry where you're not hearing his side. We listen to what has happened, we'll see what is the evidence that is already there, and we'll come to a conclusion, and then maybe you can terminate him or take disciplinary actions. Another concept is called as useless formality principle. Rather, another principle is called as useless formality principle. Let's say there are indisputable facts. in clearly in the camera you see a person coming in, you're conducting a proper activity, everybody have seen it, everybody have done it, the person is also admitted to doing it. So if there is irrefutable evidence, then in such case holding further inquiry does not make any sense, and you can dispense with it. But please to understand, this acts as an exception to the entire concept of natural justice that we were discussing. But the burden to prove later in the court that conducting any sort of inquiry would have been an empty formality lays on the employer. So if the employer is clearly convinced that there is no need to conduct an inquiry and there is enough proof to proceed with, then useless formality principle can be applied. An interesting case is Aligarh Muslim University and others versus Mansoor Ali Khan. So what has happened was that this person took leave for 2 years to go and work in a foreign university. Now, after 2 years, he have asked for extension of 2 more years, but the university said that we'll give you extension for one more year. That's it, and further extension will not be given. And if you ask for further extension and if you don't join back, it will be considered as that you're terminating the employment and will end this employment. So after 1 year, again they've said ki, you have to join back, and the person didn't turn up, and then his employment was terminated. It was challenged in the court, went to the Supreme Court, and his argument was there was no showcase notice that has been issued regarding ki we are going to conduct a disciplinary inquiry. There was no disciplinary inquiry to begin with. How can they just terminate me without any disciplinary inquiry or even a showcase notice? The Supreme Court said that we've been already issued a notice last year saying that if you don't join in 1 year, there would be consequences. So you're aware of all the consequences, you're informed of all those things, yet you didn't come. So enough opportunity was given to you to put your case and then act accordingly. Hence, the Supreme Court said that the termination stands. Do courts intervene in the disciplinary committee decisions? Often, the workers, employees go to the courts because it's an employment at the end of the day, and termination of employment is termination of livelihood. But if you look at as a thumb rule, the courts are reluctant to interfere with the findings of domestic inquiry. That is a usually seen thing. And courts often intervene if the punishment given to the employee is disproportionate to the misconduct committed. That is one thing. If they feel that the punishment is disproportionate to the misconduct, then there would be an intervention. Or if it has been proven that the natural justice is not, the principle of natural justice is violated here. In these two scenarios, yes, the court might intervene. Otherwise, generally, the thumb rule is that courts generally are reluctant to interfere with the findings of domestic inquiry. The couple of case laws which supports this, for example, Workman of Mrs. Firestone Tire and Rubber Co. Of India Private Limited versus Management and others, which said that even if no inquiry has been held by an employer, or if the inquiry held by him or her is found to be defective, the tribunal, in order to satisfy itself about legality and validity of the order, had to give an opportunity to the employer and employee to provide evidences will support for it. So, just because you go to the court will not immediately quash the findings of the committee. It will give the employer chances to provide more evidences or something to support their argument. With that note, let me conclude today's session. By now, you have gained information regarding how to conduct a domestic inquiry at workplaces in a legally compliant manner. With this, all this information, I'm sure you would be able to effectively conduct a domestic inquiry at your workplaces. With that note, let me conclude for today. You have a great day ahead. We will join back with our final session of the course, which is on full and final settlement. So we will have that session following today's session. And until we meet for our final session, you have a great day ahead. Thank you so much.